Hey, this is Attorney Patrick Korody with Korody Law, coming at you with another way to stay out of the brig. Today, we're going to talk about positive military urinalysis. But before we get to that, first of all, I'm going to remind you, number one, if you're ever read your rights, keep your mouth shut. And number two, don't consent to any type of search or seizure, whether it's your phone, whether it's your DNA, whether it's your car, your house, your barracks room, or even for purposes of this video, your urine. And today I have with me Matthew Thomas, a military law attorney out of Jacksonville, North Carolina, MT Law. Matt, good morning.
Good morning, Patrick. How are you?
I'm fine, thank you. And so, Matt, we're here to talk about military positive urinalysis, military drug tests. They've been around for years and years now, ever since the Department of Defense instituted mandatory drug testing, I believe in the late 70s. Matt, how often have you seen positive military urinalysis cases in your career?
They're one of the most common cases that we see. In fact, I would estimate that almost half of the administrative separations that go on in the Marine Corps have to do with urinalysis.
And so let's talk about sort of what a sailor, a Marine, an airman, a soldier, even a coastie, what they can expect when they test positive for a drug, a prohibited drug. And let's talk generally about the process. So the first step always is you're called into the urinalysis and you have to provide your sample. The observer is supposed to watch you pee into the bottle and then watch you bring the bottle back to the program administrator where some paperwork is signed, the bottle is sealed, placed in a baggie, put in a box, and then that box is supposed to be shipped to the drug testing laboratory where it should be tested by the drug testing laboratory for the drug panel that's provided by the Department of Defense. And after it's tested, during a preliminary screening test, if it's positive, it is then given a confirmatory test, which is a quantitative test. And the quantitative test is where you get a number as to how much of the drug is in the urine. And after that, a message is sent back to the unit indicating that the sample has tested positive, and then it's essentially in the command's hand. And Matt, what can you expect once the command gets that notification?
So immediately after they get that notification, they will pull the Marine in and let them know and most certainly offer them NJP, and they have to process that person for administrative separation. And in the Marine Corps, it's governed by the Marine Corps SET manual, and it's deemed what is a mandatory processing.
And mandatory means that they have to process them. And one thing I think that the sailors, the Marines, the airmen, the soldiers, they can all expect is when they're brought in, the first thing that's going to happen to them is they're going to be read their rights. And the reason that they're going to be read their Article 31 Bravo rights is that the command is going to want an admission. They're going to want that Marine or that sailor or that airman, they're going to want them to admit that they use that drug. And there's a reason for that, is because it really makes everything that Matt just talked about much easier. The NJP, the ADSET board, and even a court martial if they have that admission. And even in some branches, such as the Air Force and even the Navy and the Marine Corps, sometimes they'll actually bring that individual, that member, over to the security forces building or NCIS or the military police building to have them interrogated. And Matt, what would you say to a member that's brought over to be interrogated regarding this positive urinalysis?
Don't make a statement. It's easy as that. These guys, when they pull you in here, no matter if it's CID, NCIS, or even in some cases PMO, they are trained to put pressure on you and use certain tactics that once you get into that room, they want you to talk. So the best thing that you can do right when you go in is tell them, I'm invoking my rights, I want an attorney, and I'm not going to talk today.
That's right. And don't answer any questions. And if they want to look in your phone, if they say, hey, can I just look in your phone? Tell them no. One thing that I see investigators doing these days in drug cases is that they want to look at the phone, and then what they'll do is they'll do a forensic download and then do keyword searches. And they're really looking for conversations discussing drugs, how to get them, maybe drug use, the effects of drugs. And so definitely don't make any statements and definitely don't consent to anything. So let's talk about what happens after that, after sort of this preliminary investigation is done. Matt, you mentioned NJP, and that is a very common, probably the most common disciplinary action that I see with related to a positive urinalysis and a positive urinalysis only. And I say only because sometimes a positive urinalysis can accompany other misconduct, such as possession of drugs. And in those cases, those are more likely to go to court-martial. And one thing I wanted to talk about, because it's fairly new in the military justice practices, Matt, can you talk a little bit about what has become to be known as the no BCD special court-martial?
Sure. So in 2017, the National Defense Authorization Act created a new court-martial, and it is an option to give commands to send minor cases that would be, equivalent to a misdemeanor in civilian courts to what is known as a no BCD court-martial or a short martial. And what that is basically a court-martial that can only be judge alone. Now, there's good things for our clients in the sense that if they go to this short martial or no BCD court-martial, like its name, they cannot receive a bad conduct discharge or any other punitive discharge if they're found guilty. The other thing is that the judge who's sitting on the bench can only adjudge 6 months maximum confinement to them. Now, one of the problems is that clients, like its name sounds, it is a judge alone court-martial, meaning that our clients don't have the option of praying a jury trial or getting their case in front of members, which is a very beneficial in cases like these where drugs and parties and the urinalysis come into play. The second thing is unlike NJP, they can't deny the court-martial and say, I don't want to take this and I want a different option. In fact, it puts the ball in the command's court, and if they say that you're going to go to a short martial or a BCD court-martial, you're going to have to go.
Yeah, and one of the things I do like about the no BCD court-martial, Matt, is I do like the fact that the client gets the benefit of that higher burden of proof, the beyond a reasonable doubt burden of proof. And in some of these drug cases, that can be very helpful to the member, as opposed to going to an administrative separation board where the standard is preponderance of the evidence, which is just more likely than not. So in some cases, especially where our clients have good defenses, I think there could be a benefit to the no BCD court-martial.
100%. And that's why it's always good to talk to an experienced counsel before you make that decision. All these cases are fact-driven, and we have to be able to look at the evidence to kind of discern which option is better for each person's case. There are many times where I've been able to look at a file and say, hey, Marine, you need to go to the administrative separation process. Given your case, given your facts, I think this would be a better fit for you. Now, there's been other times where the evidence as it stands, by the time they come into my office, I know that we can take this to a court-martial, walk away scot-free and be able to win that case. But it all comes down to what is the state of the evidence and what are the facts on each person's case. So it's always good to talk to an experienced defense counsel who's been there before.
So let's talk a little bit about defenses. The overarching defense in these cases is that the government can't prove knowing and wrongful use of the substance for which the member tested positive for, right? I mean, that's the overall defense. Now, there are two ways I see that you make that happen. One is that there's an error in the collection or testing process such that it undermines the integrity of the result, right? And that is where the labs had messed up, or that the urine was mishandled during the collection process, or the paperwork wasn't completed correctly, or wasn't shipped in a timely fashion to the lab, that it calls into question, the integrity of the result, right? And then the second one is innocent or unknowing ingestion. Some people use them interchangeably. They probably shouldn't be used interchangeably, but essentially it's an alternative explanation as to why that positive result exists, other than that the member knowingly and wrongfully used the substance. And really, Matt, wouldn't you agree that the only way that to evaluate that type of defense is for a member who tests positive to seek an experienced counsel so that they can discuss the options regarding these defenses?
Absolutely. I mean, the NDSL, the Navy Drug Screening Lab, they have a history of poor packaging methods, testing procedure, and overall sample care. And that client or that Marine or sailor needs to be able to talk to somebody who's been there before, who is seasoned in this process, to be able to point out the discrepancies and the errors that NDSL is known to make. In fact, one of my first trials in the Marine Corps had to do with a drug pop that resulted in an acquittal because of improper handling procedures. The test levels were too high, and we were able to point that out and say, hey, this is wrong. This was a mess up on NDSL's behalf, and he was successful.
Yeah, and that's just not only NDSL, but also the Army and the Air Force's forensic toxicology laboratories. They had the same problems. And it makes common sense, Matt, right? I mean, they're testing hundreds of thousands of samples a year, and it's humans. It's often humans that, are doing mundane jobs. They're, doing these menial tasks. And hey, humans make errors. I mean, humans screw up, and it's unfortunate that those screw ups can cost a member of the military, someone that's raised their hand to serve, can cost them their career. But what we do, Matt, is we get in there and we look at it and we make sure that doesn't happen. Let's talk about civilian counsel. And Matt, what do you think is some of the benefits of hiring a civilian counsel as opposed to the military member going to their TDS or their DSO or their area defense counsel?
So in the Marine Corps specifically, the order that governs all duty rotations, or belt rotations and tour lengths, recommends that each judge advocate spends 18 months in a litigation billet, so a trial billet. And you will see that not many counsel that are in each of these offices spend more than 18 to 24 months. And so just as they're starting to learn and get their feet wet and kind of get some type of experience, they're already moved. And what you need for cases like these are somebody who's done this multiple times, whether it be an ADSAP or a court martial. So they know what to look for, they know what defenses to put on, and they know what arguments are going to be working in front of these judges. Another common misconception that I see with Marines and sailors when they go into their local office is they look and they see that their counsel may be more established or be senior in rank. And that is also a common misnomer, because as I indicated before, these counsel are rotated after 18 to 24 months. And especially in the Marine Corps, once they leave the defense office or the trial services office, they're going to spend the next several years in an administrative or a billet where they're advising commanders. So they're away from the courtroom. And, what I like to do is tell somebody, if you had a medical issue and you went to a doctor, and let's say it was for your brain, you wouldn't go to a foot doctor to have them work on your brain. Same thing. You wouldn't go to an operational law attorney or an administrative law attorney to go for your court martial. You want somebody who's experienced and has been there before and knows what they're doing in the forum that you're facing.
Yeah, and one thing that we can do as civilian counsel that the military counsel can't do is that we can actually form that attorney-client relationship immediately when we get that call. Whereas most military attorneys will tell you that they won't represent you. They're not your lawyer until you're either going to court martial, in some cases NJP, or an ADSEP board. And, the other thing that we can do is that we can start that investigation and we can start that defense right away without any waiting. We're on it, we're working it, whether it's advising to go get hair testing, whether it's requesting the urine be tested by an outside laboratory, whether it's because you believe that a substance you took caused the positive urinalysis and you want that to be tested by an independent lab. We can do all that stuff, whereas the military counsel, they will not help you the same way that we do. We provide a much higher caliber of service and responsiveness in these cases because you're not a number to us. You're an actual member whose career is on the line, and you're paying us to make sure that that career is not taken away from you for something you didn't do. So Matt, I appreciate your time here today. Do you have any final words to those who are watching this video? And presumably those are going to be military members who've tested positive for urinalysis.
Absolutely. If you find yourself with a notification of administrative separation, an NJP, or a court martial that has to do with Article 112 alpha or any type of urinalysis drug pop, talk to a seasoned counsel before you make your decision. It's imperative. It's the difference between you being able to continue your career and when whatever military service branch you're in, or going home with an other than honorable discharge, or even a bad conduct, or in some cases a dishonorable discharge. Make sure you talk to somebody who's been there before.
And I'm going to double down on that, Matt. I'm going to tell you that as soon as you find out that you tested positive, you should be calling someone like you or calling someone like me, and let's get on this and let's start that defense from that day one, and get ahead of the curve and get you in the position where you're most likely to save your career. All right, thank you very much, Matt Thomas of MT Thomas Law in Jacksonville, North Carolina. Again, Patrick Korody, Korody Law, Jacksonville, Florida. If you tested positive on a military urinalysis, call us. We'll help you. We'll do everything we can to defend your military career.